Uh, when it comes to advisory board, it would carry one third, one third, one third, one third of employer, one third of employee. Of which industry? In of which industry? That is my question. Of which industry? When it comes to advisory board, the composition of advisory board is similar to composition of committees, right? Suppose the Karnataka government has constituted a advisory board. Definitely it would have advisory board, right? You can Google it and search. Definitely they would have advisory board for Karnataka, right? In advisory board, they would appoint one third employer, one third employees, and one third Karnataka government ke representative, right? That one third employer belongs to diversified industries, right? Not of one industry, right? One third employee would represent the diversified industries, not the one single industry, right? Now Karnataka government is planning to revise the minimum wage for construction contracts or for retail employees. Okay, so what they should do? They should take the opinion of advisory board, or they should constitute a committee where one third of the retail enterprises employers should be there and one third retail enterprises employees should be there. Tell me. What is the necessity? I'm just resolving that only. So definitely they need to have a specialized opinion, right? They need to form a committee where only person who is expertise having in construction area should be the part of the committee, right? They can get a common opinion from the advisory board, but for a specific opinion they would need what, beta? Committee. Got my point? Yeah. Again, tell me if you are having more.
If the advisory boards are not industry specific,
Huh.
so there will be so many, because the limit of members is not specified.
Hmm.
So there will be so many members. For example, take employees. Employees will be having from different industries. So that is already including one industry that is going to be required. So this board is advising to the committee, and that committee is advising to the government.
Government. Yes.
The chain can be made here. Like the board can already advise the government directly.
See, beta, when it comes to say in advisory board, can I say that if there are 20 employee members, hardly one employee will represent the construction organization, right? So when it comes to advisory board ka opinion, it will be given by the board or that single employee. It would be given by the board, means it would be a collective common opinion given to the state government that now you have to revise the minimum wage rate for construction business, right? It was just a bare opinion, a common opinion, not a specific opinion given by the board to whom? And who is having the better understanding of construction business? Those who are working in construction business, right? So based on the opinion given by the advisory board, the government will form a specific committee having expertise in construction business, so that they can determine what rate should be paid to the construction worker, right? So if that rate would be determined by the advisory board, can you think that it will be a justified rate? No. When it would be a justified rate? When it will be determined by the construction workers, right? Right? That is why committees are required. Got my point? So there would be several committees or subcommittees, right? But advisory board is a unique entity having only one status. Got my point? Is it clear? Good question. So keep analytical approach. So overall, if I analyze the minimum wage law from the point of view of legal consultant as well, I would understand that if I need to have a clear understanding of a minimum wage law, I have to go through with the state rules very specifically, right? Even schedule may change from state to state. State has been provided with so much flexibility on implementing the law. The central act is just acting as a base for the minimum wage law. It just mandated that you have to pay the minimum wage, otherwise you would be behind the bar. If you are really want to enjoy the status as an employer, pay the minimum wage. Don't deprive your worker from getting the minimum wage, right? But what would be the minimum wage is going to be defined and determined by whom? the state government, right? In almost cases by the state government, but for certain industries it is going to be determined by the central government. In future you will have uniform minimum wage rates, right? In future you will have living wage, right? Right, students, what is the difference between living wage or minimum wage? What would be more? Living wage would be more and minimum wage would be lower, right? Under this enactment, as of now, no authority has been established. Only boards has been established, right? Committees and boards has been established. And what is the role of committees and boards? They are supporting the government, right? They are supporting the state government to function on minimum wage matter, right? Committee supporting to determine the minimum wage rate, advisory board helping out the government to implement the law, right? What is the role of advisory board? Advisory board would help the government that how to implement this law, right? But the committee would determine the minimum wage. Got my point, students? Is it clear? Now proceeding further. Composition I taught, right? Minimum wage payment to be made in cash or kind. So generally minimum wage should always be paid in what, beta? Cash. Generally it should be paid in cash. It should be means a criteria that minimum wage should be paid in cash. But if there is a customary practices means from the custom and usages of trade, from the very beginning they are having a uniform practice to pay the wages in kind as well, okay? Means it was their traditional practice that 70% wages they used to pay in cash and remaining they are paying in the form of some goods, right? Goodies, right? So in that situation, if there is a prevailing customary practice that they are going to pay a proportion in cash and proportion in kind, then you can pay the proportion of minimum wage as in kind. Got my point, students? If there is a customary practices, right? Right? Have you ever gone through with the contract law? Even in contract law, that is always written. If the custom says something, the custom will prevail, act will not prevail. Remember? Remember, students? Even contract act as a weaker nature of law, which bow downs in front of customs, right? If there is some customary practices which is clashing with contract law, what will prevail? The customs, not the contract law. In the same way, minimum wage should be paid in cash. It is being written in the law. But if there is a customary practices, what would prevail, beta? Customary practices, not the law. Yesterday we have understood one legal principle. If there is a contradiction between contract and the act, what will prevail is the act. Remember, if all my employees agreed that, Rahul, okay, you are facing so much losses, we don't want to bother you, do one thing, pay us whatever you want to pay. We are not bothered about minimum wage for a year. We are supporting you out to sacrifice our minimum wage. Pay us below minimum wage. Can I pay them below minimum wage? Answer would be no. Any such contract would be null and void, right? If my all workers are coming together and saying that, Rahul, you are really facing cash crisis, cash crunch, you don't have enough cash, do one thing, this month ka wage pay us by next month. Can I pay them by next month? No. If I would pay, that would be a contravention of what? Payment of wages act, right? So whatever contract that has been done in contradiction of what? Law would not prevail, right? Right? Repeat whatever I have taught now. You, blue t-shirt. You were not in the class, right? Tell me what I have explained, beta. Explain what I taught about the contracts. Or tell me you were not in the class, right? Understood everything? Should we proceed further? Now they are saying that even if there is a customary practices, you can pay the minimum wage in kind, and if there is an authorization given by the government, if government is saying that you can pay the minimum wage by essential commodities, but beta, what is essential commodities? Essential commodity includes food grains, vegetables, fruits, and it includes what, beta? It includes medicines, right? right students? What is essential commodities? Food is essential commodity, right? Fruits are essential commodities, right? And vegetables are essential commodities, and medicines are essential commodities, right? So you can pay minimum wage in the form of essential commodities as well if authorized by the appropriate government. Got my point, students? Is it clear? Whose obligation it is to pay the minimum wage with the employer, right? You cannot make any deduction from minimum wage, right? You cannot make any deduction from minimum wage, right? And you have to make it on timely payment, right? Now I'm proceeding further. Now they have defined the term minimum wage, right? They said that you have to pay the minimum wage to your worker, right? Now there may be other way around where the employer can exploit the employee by fixing unnecessary working hours. Can I say that, right student? It can be the case now, right? If the government has come up with minimum wage law and they are saying that you have to pay 19,000 per month to your worker, but they are not defining the working hours, then how the employer will start exploiting the employee? They'll announce that now the working hours will be 10 hours a day or 12 hours a day or 15 hours a day, right? Right students? So there can be other way around where the exploitation can be made by making the worker work for overtime with the same wage rate, right? So can I say that minimum wage law is insufficient and incompetent if it is just defining the minimum wage but not defining the normal working hours, right? So the other part should also be defined by the law. So what would be the normal working hour? It would be what? What would be the normal working hour? We know that 8 hours a day, and week mein how many days one should work? 6 days. 6 days a week, right? In India, there is 1 day weekly off, right? Certain 1 day weekly off is mandatory. In UAE now they have come up with, I think, 4 days working, right? Where 3 days will be holidays and 4 days would be working period, right? So, but in India, many organizations by their own policy has made 5 days working, 2 holidays, right, in the week. But still there are workers who are working 6 days a week because statutory norms is what? You can work with 1 weekly off, है ना? 6 days you have to work and maximum working hour can be 8 hours a day, right? So total of weekly working hours can be spread over 48 hours, right? If you will work on holidays, it will be counted as a overtime, and if you are working more than 8 hours a day, it would be counted as a, suppose you have worked for 9 hours on Monday and 7 hours on Tuesday, still 1 hour worked on Monday will be counted as overtime. Got my point, students? Is it clear? So now fixing the minimum wage rate without referring to the working hour may not achieve the purpose of this law. Logical, students, right? Now thus by virtue of section 13, appropriate government may fix the number of working hours which shall constitute a normal working day, inclusive of one or more specified interval. Everybody is getting an 8 hours 30 minutes ka lunch break, right? Daily intervals are going to be determined by whom? Beta, government only, right? Now provide for the day of rest in every period of 7 days. Generally everyone over here in India is getting Sundays holidays, right? Now provide for the payment of work on the day of rest at rate not less than the overtime rate. I told you, right? If you are working on the holidays, it will be counted as what? Overtime, right? So can I say that now in section 13, government understood that if they'll come out with minimum wage but not coming out with normal working hours, the employer will start exploiting the employee by expanding the working hours, right? They'll increase the working hours. In that situation, again the exploitation of worker will start. So under section 13, government is going to determine what? The normal working hours. And we know the definition of normal working hours, that is what? Every day maximum 8 hours with minimum 1 or 2 intervals as may be defined by the appropriate government. Total working hours for a week should not exceed 48 hours, right? Minimum 1 weekly off is mandatory, right? And the fifth thing is what, beta? If you are working more than 8 hours a day or more than 48 hours a week or on holiday, it will be paid off by overtime. Got my point, students? That is what? section 13. Is it clear? Got my point, students? Now the above stated provision shall apply to the following cases of employee only to the extent subject to such condition. Employee engaged on urgent work or in emergency which could not have been foreseen or prevented. Employee engaged in work of a preparatory or complementary work which must necessarily be carried on outside the limits laid down for general working employment condition. Now they are saying that these 8 hours or other things will not be applicable if your work require preparation. If your work require what, beta? Preparation. Like something you have to get it done, then you have to come to the office and finish your work. Okay. So the preparatory task would not be counted as working hours. Is it clear? So if you have to prepare, suppose as a lecturer, if I am taking the lecture, right, I will be paid off for the lecture hours, right? But I have to prepare the notes, right? I have to prepare the notes, I have to prepare the material, I have to prepare the revision material, right? Will I get paid off for the same? Answer would be no, right? Preparation is the necessity to perform the work, right? Preparation is the necessity to perform the work. So the preparation hours would not be counted in the normal working hours. Point number 1, is it clear? Point number 2, they are saying that if you have to work on emergency situations, like there is fire broke on in the office, okay, in that situation, if you work for emergency, it would not be counted as an additional or overtime work. Is it clear, students? So to work would not be counted as an normal working hour if you are getting into preparatory work or if your work requires to prepare, right? And the second one is what, beta? Work on emergency. Got my point, students? If you are an intermittent worker, just go through with this, then we'll proceed further. Okay, what we have studied, beta? We have studied whose duty it is, and it should be paid in cash when it can be paid in kind. And the last thing what we have studied is what is normal working hours. Is it clear? Go through, then we'll go proceed further. Done, students? What was the first point after break? Can you pay the minimum wage in cash or kind? You can pay in kind as well. But when you can pay in kind? In two situations. The first one is what? When it was a customary practice, or second is when authorized by the government. But if the government would authorize, they'll ask you to pay in the form of essential commodity, not otherwise, right? The next question is what? Who is under an obligation to pay? That is employer. And why there is a need to determine the minimum normal working hours? Why there is a need to determine the normal working hours? Can be other way around, right? How the exploitation can be done? If the minimum working hours would not be, normal working hours would not be determined, then the employer will start making them work for extra hours, right? So in order to protect the exploitation, just to determine minimum wage would not be the solution, right? Just to determine minimum wage is not a solution. Solution should be what? It should determine what? Normal working hour. Now what do you mean by normal working hour, beta? What is normal working hours? 8 hours a day with minimum 1 or 2 interval, that is called short break, as may be determined by the appropriate government. The third one is weekly maximum 48 hours. The next one, weekly 1 holiday is mandatory. Next, if you are working for more than 8 hours, more than 48 hours, or on holiday, it would be counted as an overtime. And for overtime work, you will get double the ordinary rate, right? Right, students? Now they are saying that you can work for more than 8 hours or more than 48 hours, or you can go for overtime work and it would not be counted as overtime work. Point number 1, if you have worked for emergency, right? If you have worked for emergency, right? When you are preparing for your work, that preparation hours would not be counted as an overtime hours, right? When you are into an intermittent work, means you are a seasonal worker, or you are not a permanent worker, you are a temporary worker, you are coming for a seasonal employment, or you are being called upon for some additional work, okay? So intermittent worker per what is not going to be applicable is normal working hours, right? Then if you are into a work which is required to be finished before your shift, is over because of technical reason. Means you have to get it finished. If you'll not finish it up, it will create a problem. Then just like if I am finishing up the lecture, then I have to organize all the videos that has been recorded after during the lecture. So I have to sit for 30 to 45 minutes with the technical guy who is helping me out to sort it out the videos. Okay. So what I'm finishing my shift by 9:15, but still I have to work till 10, right? So will I get any additional payment for 45 minutes? Answer would be no, because it is essentially required because of the technical reason. Otherwise my video would be missed out, right? And it would not be organized if I would not provide the proper support. My work would be worthless in that case, right? Got my point, students? So how many exceptions are there? 4. First one is what? Emergency. The second one is the third one is intermittent worker. Fourth one is technical reason, right? Right, students, is it clear? Fifth one is when the nature of work you are doing is based on season or nature. Means your work is totally dependent upon the natural elements which is beyond the control of the employer. Is it clear? Got my point, students? In 5 situations you are not going to get any additional payment for overtime work. It would not be counted as an overtime. This question may be asked. The first one is preparation. The second one is, the third one is intermittent work. Fourth one is technical reasons. Fifth one is natural reasons. Right? Got my point, students? Is it clear?
This provision is only for the overtime or even
For overtime. For overtime.
because overtime is basically twice the
Twice the rate.
So will that be like if I am working 9 hours? Because if I am working 9 hours and
You will get one single payment in that situation. You just wanted to ask that, no? If you have work, you are not going to get payment for any these things. Okay? Like if for preparation you are not now we should go logically, right? For preparation, will you get any payment? Answer would be no, right? For technical reasons, will you get any kind of payment? No, it is a part of your work. You have to get it finished, right? Because of natural reason, if you are working overtime, definitely you are going to get the payment because you are working more, right? But with normal rate, not with double rate. Is it clear? For emergency, if you are working, definitely if you are working in the emergency of organization, you are going to get the single payment, not the double payment. Is it clear? So it would be totally depend upon the fact and circumstances of cases. If the nature of additional work is essential to finish your original work, you are not going to get any additional payment, right? But if you are working overtime, right, because of the need and necessity of employer and it is not being counted as an overtime work, you will get the single payment. Is it clear, students? Got my point? Good question. Payment of overtime, we know that. How much will be paid, beta? Double. Generally, appropriate government will determine, but generally how they are determining? Double the original rate. Right? Right, bachon? If you are not working for normal working hours and there is a fault of employer, suppose I came for the shift, my shift was of 8 hours, okay, they was not having appropriate work or a proper work to be given to me, they have laid off me for that day. They said, Rahul, you have worked for 3 hours, now you may leave. They have to pay the wage for the full day, right? Because it is their fault, right? Right, students? So if I have worked for less than the normal working hours, I'll get the full day payment, right? Right, students? But if it is because of my reason, I was unwilling to work, right? In that situation, they are going to pay me the proportionate payment, not the full payment. Is that clear? Got my point, students? So, after break, how many sections we have done, beta? We have done with section 13, that is fixing the normal working hour. Section 1 was applicability, 2 was definition, 3 is not that much important, 4 is not important. I think 5, 6, 7, 6, 7 is very important, right? That is advisory board and all, right? Right, students? 5, 6, 7, 8 is very important. 5, 6 is committee and notification, 7, 8 is advisory board, right? Right, students? Next, 13 is very important, fixing the normal working hours, right? 13 is very important. 13 and 14, right? 15 is okay. You have to maintain adequate registers and records, right, students? And they are not asking about any preservation period, right? So the preservation period is going to be determined by whom, beta? Appropriate government, right? If the central law is not talking about preservation period, there it was 3 years, right? Here they are not defining. So if they will not define, then appropriate government will define, right? Is it clear? Read till section 18, then I think a small part of this chapter is pending, right? I told you that Delhi government has come out with 3 years imprisonment, right? According to central law, imprisonment term is 6 months. But from the point of view of Delhi government, now the imprisonment term is 3 years, right? If you fail to pay the minimum wage rate, right? Right, students? Done, students? Then now they are saying section 20. According to section 20, state government would appoint the appropriate authorities to take care of this matter. We know that implementation rights are there with the state government, so authorities are going to be determined by whom? Now who would be the complainant, beta? The complainant can be the leader of the trade union, the affected employee who has not been paid minimum wage, right? Who did not pay the overtime paid off with the overtime wage rate, right? Or who has worked for more than normal working hours, right? He may file a complaint with the appropriate government, right? Means the appropriate authority appointed by the appropriate government, right? That can be a labor commissioner, commissioner of workmen compensation, etc., right? There is no limitation period provided, right? You can file complaint anytime. They have not defined the limitation period. There was a limitation period of 12 months, right? There is no resolution period even, right? Right? No resolution period has been given. There it was 3 months, right? Right, students? And here there would be an imprisonment, fine, or both. So it is not required that always the government will come up with the imprisonment. It would be totally dependent upon the court will determine as per the fact and circumstances of the case. If the case is like it was not his fault, he is a new entrepreneur, he doesn't have proper knowledge of law, and it was his first default committed by him, government may relieve him with the fines only, right? But if it is a repeated nature of offense, then in that situation government will come up with, court will come up with punishment as well, right? Imprisonment as well, right? Right, students?
If minimum wage act does not prescribe any limit of application for the default, so at that point, payment of wages act will prevail.
No, no. See, when it comes to, if nothing has been defined over here, either it can be defined by the appropriate government, right? Logically, appropriate government can determine that you can put the matter with the concerned authority within that time limit or time period only, right? Otherwise, whenever you will put the case, it will determine by the court based on the fact of the cases whether your application is entertainable or not, right? Right? Until and unless law will provide expressly that if something has not been provided under this act, you have to follow Payment of Wages Act. We cannot follow it. Is it clear?
So, sir, payment of wages act is about wages only, and this is also wages.
See, beta, have you ever gone through with interpretation of statute? Whenever you are reading law, you have no authority to add anything from your part. Whatever is being written in the law, you have to stick to that. You cannot use common sense like if both are wages related law. If nothing is being provided over here, we will follow Payment of Wages Act. If expressly it will be provided, in certain provision they have provided that if this act is silent, follow Payment of Wages Act. So expressly they have provided for it. If they have not provided anything expressly, we cannot follow anything. It will be determined by the court how the matter will be sorted out. Is it clear? But we can understand this is going to be a summary matter because vast public interest is involved in this matter, right? So important sections are section 3, how to determine the minimum wage. Section 4, that is a state government would have an option to adopt 3 approaches. Section 5 and 6, how to determine the minimum wage rate, that is called committee method and notification method. 7 and 8 is very important, that is related with advisory board, 7 and 8, right? And then after, I think important is section 13, that is minimum working hours, right? Permissible working hours, right? Normal working hours. Then after 13, I think 20 and 21 is okay, related with what? Penalties, right? Right, students. So we have done with what? Minimum wage act, right? I have added 3 case studies, 3 news. Have you checked the news is added by me in the notes? Have you checked it? Now see, the past year papers में few case laws are there. Should we discuss it, beta? Should we discuss? See the first question. An out worker prepare goods at his residence and later on supplied these goods um, to the employer. Will he be treated as an employee under Minimum Wages Act? What do you have to write, beta? You have to write the definition of employee, right? Employee includes what? Any person who has been appointed by employer directly or indirectly through contractor, right? It includes he may be appointed for skilled work, unskilled work, clerical work or manual work, right? By whatever terms he has been appointed, he would come under the definition of employee. But it does not include what, beta? Apprentice, right? It does not include what? Person who has been appointed to perform unscheduled employment. It does not include armed force people, right? Right, students? But it includes what? Out worker. Then in conclusion, you should write as per above explanation, as the act and the judicial precedent clearly specified that out worker or a gig worker would be classified as an employee if his nature of work is what, beta? Permanent or continuous, he will come under the definition of what? Employee. Is it clear? Got my point, students? Now how you should write the case study? First write the legal provision, then write the conclusion. Okay. Now a company was running into losses and was unable to pay the minimum wages of to the worker. The worker pleaded that the employer must pay them the minimum wage. You have to pay, by right? You have to pay. You are suffering losses, that is your problem, that is not the problem of employee, because to pay the minimum wage is the statutory duty, right? To pay the minimum wage is your statute, it cannot be denied with any excuses, right? Right, students? Now direct question, in June 2024 they have asked, write the procedure for fixing and revising minimum wages under Minimum Wages Act. It was a long case study question, that long story wala question, and last when they have asked, tell us the procedure how the minimum wage will be revised. Section which that is section 5 and 6, right? 5 was committee method and 6 was notification method, right, students? So done with everything. Now you guys can check past year papers ka link. I must have put it over here. I haven't put, I guess, right? No, I'll put it. Okay. Past year questions, those case study based question I have put it over here. Those direct questions I haven't put it. Okay, direct questions they have asked. Okay. So can you guys do it? Just revise it for 2 minutes, then we'll start with what, beta? Payment of bonus act. It is quite interesting but little technical. Is it clear? These 2 laws were simple. Online students, please revise it once, okay, thoroughly from the notes, then we'll proceed further. You guys are willing to take the printout of the notes, that's why you were asking, no? I can give you past attempt ke notes, but I think I haven't used icons and all, so it is not that much, proper like the notes I am preparing now. So I think wait till the last lecture, then we can get it printed, no? Right? And refer only these notes, don't refer anything else, right? It is, if you have, do anyone have matched it up with the study material? Have you seen study material is too intense and unnecessary explanations and etc. has been given in, study material, so it's better to, but and the study material does not cover past year papers, right? So ultimately, if you will refer a study material, you have to refer for past year papers again. So I am covering everything, every aspect is there. So you need not to refer any other. Is it clear?
The PDF that you have sent, the recent one is
additional chapter. That is
That is
payment
fine.
payment of bonus. And every day I'll share whatever topic I'm taking. Every day I'll share it. On the last day you can get it, right? Yes, sir. Revise it properly with a read once. Okay, don't talk with each other. What I asked for, I asked for reading. Should I give one question? You'll write it. Even online student, yes, online student can write the question. Right.
So for example, like today whatever topic we have studied, give the question of it tomorrow so that it will match with the notes and all.
I didn't get you. What you?
Like for example, you taught us minimum wages act.
Hmm.
So you will give the question related to this.
No, I am giving the question related with Payment of Wages Act. Now, no. So I am giving you the question of Payment of Wages Act because today only I have covered the Minimum Wage Act. Na? So how I can expect you to write answer of that, right?
Yes, sir. Yesterday part, I have little doubt, sir. Like compensation part, you told like 10 times more will be deducted.
It is equals to 10 times of the deductions or 3000, whichever is lower. Whichever is lower. Because in any situation, the compensation cannot be more than 3000. So it would be whichever is lower. Is it clear? But although even from the point of view of exam, I don't think learning the penalty will be the solution. I told you learn monetary or criminal penalty, right? If it is criminal, it is not compoundable. If it is civil, it is compoundable, right? And yesterday even we have discussed about compounding. What is compounding, bachcho? What is compounding?
Like we have only done fault, like proving, agreeing that we have done fault,
What?
agreeing that we have done this mistake, and
Suppose an accident happened with me in front of this academy, है ना? And the concerned person is like, I am going to police, you have done wrong with me, and he is asking me, Rahul, see, you are not so much injured, take 5,000, 2,000 or 1,000 and settle the matter with me. Why? To make it a police scene, right? So can I say that we have compounded the matter? Can I say that we have settled down the matter, right? I'm not filing complaint against him because he has paid me 1,000 rupees, which would be the treatment cost for me, right? Can I say that? In the same manner, can we settle the wrong committed by us with the authority? Answer would be yes, right? But such wrong should be an innocent wrong. It should not be a malified wrong. It should be a bona fide wrong. It should not be a malified wrong. What topic we are studying? That white shirt. What? Yeah. Which topic we are discussing about? What? Compounding. What is compounding? Compensation. To pay compensation is known as compounding, right? Wow. Is it? Physically he is in the class, mentally he is somewhere else.
In books, it is compensation.
In the book it has been written as a compensation. Where? No, beta, it is a kind of, it's not a it's not a compensation. Actually, see, you are just paying a nominal charges, right? Like if you are compounding is technically used with the authority, not with the individuals, right? I have just given an example of settlement. It was a settlement. It was not a compounding. For compounding, you have to approach whom? Authorities. If you'll go through with FEMA, there is a provision of compounding. If you'll go through with company law, there is a provision of compounding. If you'll go through with competition law, there is a provision of compounding. In several laws, there is a provision of compounding where the innocent person, the bona fide person who has committed something wrong by mistake is being provided with an opportunity, go and with folded hands, right, ask the concerned authority that it was my mistake, I have done the mistake, it was a bona fide mistake, not a malified mistake, it was very first time I have committed the mistake and I am not capable enough to pay you crores rupees ka penalty. So please take it like that and charge a nominal fees from me, that is called compounding charges, and once they'll take the compounding charges now beta, I would be relieved from that offense. Again they cannot restart a fresh case against me for the same nature of offense because it has already been resolved and settled. Is it clear? And there is one more principle for compounding. There should be a gap of minimum 3 years between two compounding. Is it clear? Means if in 2021 I have committed something wrong, then and I have get it settled down with the authority. Now in 2024 I can demand for compounding. Again if I, in every act there should be a gap. Every act same three principles will be applicable. Compounding is only applicable when the matter is related with fine, not with imprisonment. Only bona fide matter can be compounded. There should be a gap of minimum 3 years between two compounding, and fourth you pay the compounding charges and you will be relieved from the offense. In all laws these four principles are applicable when it comes to settlement. Is it clear? But there should be an express provision of compounding in the law. You cannot add it on. Is it clear? Got my point? Now don't talk with each other, just read it once. I'll call the concerned person. I have to settle the new notes in the system. Okay.